Imagine an elderly widow in Addis Ababa, recently bereaved and living alone. A smooth-talking representative from a construction company knocks on her door, places a thick document in front of her, and asks her to sign. She does. Months later, she discovers she has signed away her land for almost nothing. Can the law help her? This is exactly the kind of situation Ethiopian contract law addresses through the doctrines of reverential fear and unconscionability. Let us begin with the exact words of the Civil Code. Article 1709, titled Reverential Fear, states, "Fear of an ascendant or a superior shall be no ground for invalidating a contract where no duress was exercised." The provisions of sub-art 1. Shall not apply where the contract was made with the person inspiring the fear and such person derived an excessive advantage from the contract. Article 1710, titled Unconscionable Contract, states, "A contract may not be invalidated on the sole ground that its terms are substantially more favorable to one party than to the other party. Where justice requires, any such contract may be invalidated as unconscionable where the consent of the injured party was obtained by taking advantage of his want, simplicity of mind, senility, or manifest business inexperience." Now let us break these provisions down element by element. The starting point of Ethiopian contract law is freedom of contract. Parties are generally free to negotiate and agree on whatever terms they choose. This freedom is the foundation of commerce and personal autonomy. The law respects the choices people make, even when those choices appear unwise to outsiders. A person may sell something cheaply because they want quick cash, because they value the buyer's friendship, or for any number of personal reasons. The law does not second-guess such decisions lightly. This is why Article 1710, Subarticle 1 declares a critical principle. A contract cannot be invalidated on the sole ground that its terms are substantially more favorable to one party. Read that carefully. Even if the deal is lopsided, even if one party gets far more value than the other, that imbalance by itself is not enough to set the contract aside. Inequality of terms alone is not unconscionability. This protects the integrity of contracts and prevents people from running to court every time they regret a bargain. But freedom of contract is not absolute. Article 1710, Subarticle 2, introduces an exception where justice requires intervention. This subarticle establishes a two-part test that students must memorize. First, the terms must be substantially more favorable to one party. A minor difference in value is not enough. The disparity must be significant and substantial. Second, the consent of the injured party must have been obtained by taking advantage of a specific vulnerability. The law identifies 4 specific vulnerabilities, and only these 4. The first is want, meaning financial need, poverty, or economic desperation. The second is simplicity of mind, meaning a lack of intellectual capacity or sophistication to understand the contract. The third is senility, meaning vulnerabilities associated with old age and cognitive decline. The fourth is manifest business inexperience, where one party is clearly a novice in commercial dealings and the other party takes advantage of that inexperience. The word manifest is important. The inexperience must be obvious and apparent, not hidden. Both elements must be present together. Substantial imbalance without exploitation of a vulnerability is not enough. Exploitation of a vulnerability without substantial imbalance is also not enough. Only when these two elements combine does Article 1710-2 come into play. Notice also the phrase "where justice requires" and the word "may." These two pieces of language give Ethiopian courts important discretion. The word "may" indicates that the remedy is not automatic. Even if all the factual conditions are satisfied, the court still retains the power to decide whether invalidation is the appropriate response. The phrase "where justice requires" anchors the doctrine in equitable principles. Ethiopian contract law is not purely mechanical. It incorporates a sense of fairness and conscience. Now let us turn to Article 1709 on reverential fear. Reverential fear is the fear we naturally feel toward those in positions of authority over us, such as parents, employers, religious leaders, or elders. The general rule is that mere fear of an authority figure is not enough to invalidate a contract. If your father pressures you to sign a contract with a third party, that pressure alone, without actual duress, does not invalidate the agreement. However, Subarticle 2 creates an exception. If the contract was made directly with the person who inspired the fear, and that person derived an excessive advantage from the contract, then the protection kicks in. This logically connects to the unconscionability doctrine. Where a power imbalance between parties is combined with excessive advantage-taking, the law is prepared to offer relief. Together, Articles 1709 and 1710 form a coherent framework that protects vulnerable parties from exploitation while preserving the general principle of freedom of contract. Let us now apply these rules to concrete scenarios. Consider first the desperate farmer. A farmer in rural Ethiopia faces a failed harvest and has no money to feed his family. A wealthy grain merchant approaches the farmer and offers to buy his land, which is worth approximately 500,000 birr, for just 80,000 birr. The farmer, desperate for money, signs. Under Article 1710, this contract could be challenged. The terms are substantially more favorable to the merchant since the price is only about 16% of market value. The merchant obtained the farmer's consent by taking advantage of his want, his dire financial poverty. Consider next the elderly widow we met at the beginning. An 80-year-old woman, recently widowed and living alone, is approached by a construction company. The company convinces her to sign a contract transferring usage rights over her land in exchange for what seems like a lump sum payment, but the fine print strips her of all land rights permanently. She does not fully understand what she is signing. Here, the widow's senility, or at least her vulnerability due to age, combined with the substantially imbalanced terms, could form the basis of an unconscionability claim. Consider next the first-time trader. A young entrepreneur who has just started a small import business enters into a supply contract with an established foreign distributor. The distributor knows this is the entrepreneur's first major commercial contract and inserts penalty clauses, exclusivity restrictions, and pricing terms heavily skewed in its favor. If the entrepreneur's manifest business inexperience was obvious to the distributor and the terms are substantially more favorable to the distributor, an unconscionability claim is possible. Finally, consider what does not count as unconscionability. A mid-size retailer negotiates a bulk purchase contract with a supplier. After careful negotiations, the retailer agrees to prices that later turn out to be higher than market rates. 6 months later, the retailer wants to void the contract. This would not meet the standard. Both parties are commercially sophisticated. There was no exploitation of want, simplicity, senility, or inexperience. The mere fact that the terms turned out to be unfavorable, even substantially so, is expressly insufficient under Article 1710(1). The contract stands. The doctrine targets exploitation, not regret. Now for your exam tips. Remember these key points. First, inequality alone is not unconscionability. Article 1710(1) protects freedom of contract even for unequal bargains. Second, master the two-part test. Substantial imbalance in terms plus exploitation of a specific vulnerability, and the 4 vulnerabilities are want, simplicity of mind, senility, and manifest business inexperience. Third, the remedy is discretionary. Courts may invalidate where justice requires, giving judges equitable flexibility. Fourth, distinguish unconscionability from other grounds for invalidation like fraud, mistake, or duress. Fifth, remember that Article 1709 on reverential fear provides related protection when the person inspiring the fear was the counterparty and derived excessive advantage. The burden of proof lies on the party seeking invalidation. Approach every fact pattern carefully, identifying both elements before reaching a conclusion. Thank you for watching. Whether you are a law student preparing for your exams or a member of the general public curious about how Ethiopian law protects vulnerable people, we hope this lesson has been helpful. Please subscribe for more clear, practical explanations of Ethiopian law and share this with anyone who might benefit. Until next time, keep learning.